Good afternoon and welcome to the North Sydney Local Planning Panel. We are complying with all of the COVID regulations, as you can see, and our procedures also are transparent and in accordance with our requirements under the various legislation. I would like to just open and say that this afternoon we have 6 matters on the agenda, and we are dealing with these matters one as they are on the order of the agenda. And what we will be doing will be, first of all, inviting any people who made a submission or has asked or requested to speak this afternoon to address the panel. Then we invite those to do so first, and then we invite the applicant and his representatives, architects and planners. In the first instance, I would like you to respond to what you may have heard in submissions, and then present your position to the panel. I am Jan Morell. I've chaired the panel for since its inception, and I sit on a number of other panels in the Sydney region and also a state panel, and that is my only line of work. And prior to my retirement some 8 years ago, I was a commissioner with the Land and Environment Court for 14 years, and prior to that I held positions as senior planners in local government and the state government. I'll ask the other panel members to introduce themselves to you. Thank you, John.
Yes, my name is John McInerney and I'm an architect and town planner, and I am the past Deputy Lord Mayor of the City of Sydney, and sit on a number of panels, as does Jan. Thanks.
Hi, I'm David Brigdon. I'm a solicitor. I have specialised in environmental planning law since 1978. I had been with the department. I've been the head of the legal branch there, went to Freehills and then to another major national law firm after that. Now semi-retired, and I also lecture in environmental planning.
Thank you, Ken.
I'm Ken Robinson. I'm the community representative on the panel. I'm a retired environmental scientist and planner, and this is the only panel in which I sit.
Thank you, everybody. So without any further ado, we'll move to the first item on the agenda, and that is 314 to 316 West Street, Camaray. And I have the town planner listed to speak on this item, but I do not have any objectors who wish to address the panel. I would like to say, in respect of all items on the agenda, that we have read any further submissions that have come through for the panel, so I acknowledge those at this point in time. So if I could just invite, before we do invite people for the first item, the panel members need to declare whether they have a conflict of interest. Thank you, Robin. On any items on the agenda. I do not have any conflict.
I have no conflict.
I have no conflict.
And no conflict.
Thank you. And also that becomes public knowledge and publicly recorded. So we have the first item, which is 1 West Street, and it's Paula Motek. Paula, are you online?
I am, thank you, Chair. We were really just available to answer any questions the panel might have today. We didn't necessarily want to make a presentation per se.
Okay, and Rebecca Gordon also. Is Rebecca there?
Yes, thank you, Madam Chairman. I'm here also to answer any questions that the panel may have about the application.
Very well, thank you. I will say that we have all inspected the site, and I'll just see whether the panel members wish to ask you any questions. I, for one, note that this has been a significant amendment from when it was before the panel previously, and I do not have any problems or any questions I wish to ask you, but I'll turn over to the panel members. Thank you.
I have the same comments as the chair and have no questions.
I also.
Thank you. Sorry? Oh, the bins. Yes, the garbage bins.
Oh,
yes.
No, you do.
Yes, yes.
I
John McInerney speaking.
Thanks. It's in respect, you may have noticed one of the conditions requiring a communal bin, if I could call it that. Had you not, it's actually condition
C13.
C5, I think,
C5 and then C13
and C13.
about the waste.
In your plans, let me make clear the issue is that in your plans you had shown garbage bin containers for each of the particular units, for each of the 7 units, accessible directly to the street. What the council's conditions require is a communal common garbage bin area, collection area, which of course would require a garbage collection company and a certain reasonable costs associated with it. And I was just wondering if you had any comments on that condition.
Just to answer that question, we had always proposed that each individual of the 7 dwellings would operate their own garbage as per a normal townhouse type dwelling. And that was because it was seen to be a much easier way of managing waste in accordance with the other dwelling types in the street. We didn't have our preference is certainly to do it in that way, but if council is of a mind that that's what's required, but as I said, it wouldn't be our preference to keep that as common, as a common space in the basement or whatever.
We don't know why. If it was a house, you'd put the garbage bins out on the street. The first time I've seen this condition, we live with it if we have to. I can't see the benefit of it certainly from the residents' point of view, it's a big disadvantage. From the point of view of the council, if the council garbage pickup system doesn't want to pick up bins from the street, that's another matter. That's obviously a matter of public interest.
Thank you. And there's one other question we have as well.
With respect to the possible salvage of materials from the 2 existing buildings there, both interwar buildings with good brickwork, good timber, and probably some other matters, joinery that certainly would be worth salvaging and possibly even might make some money for the builder. We were thinking of a condition which would be more demanding in return, or in terms of maintaining or retaining salvageable material rather than just tossing into a bin. If you like, I could read some words out as to respect of that, if that would help.
Yeah, that would be appreciated. Yeah. Thank you.
I mean, in general, we're keen on reusing materials whenever possible, and certainly the timber would be reused. In practice, in any case, we would reuse all the timber, demolish all the timber, and any of the fireplaces and so on. In practice, we would always keep the timber, the roof framing, the fireplaces, doors, and such alike. We would keep the floor framing and floors. Is difficult in practice to deal with. The bricks, we have to keep the bricks. We'd reuse the bricks.
You'd reuse the bricks, would you?
Yeah.
Yeah. Look, this is the condition that we've been thinking about. Just a suggestion that, and I'll read it: original decorative architectural features and building materials within the existing buildings are to be salvaged for reuse within the development or the wider community. Plans and specifications which comply with this condition must be submitted to the certifying authority for approval prior to the issue of a construction certificate. The certifying authority must ensure that building plans and specifications submitted fully satisfy the requirements of this condition. Would that be a difficult condition for you?
I find it a bit hard to follow exactly.
I think so long as we would certainly anticipate using what we could in the development itself, but so long as it's specified that it could otherwise be used in the wider community, I think that's fine.
Yeah,
I think that's our interpretation, actually.
Can I say, with respect to this garbage, what is the reason for the garbage disposal condition?
Well, that is an engineering requirement of the waste management people of the council. We have been considering the fact that these are more multi-unit style development, and as such that people may be inclined, as you indicated, to wish to manage their own collection and putting out of bins, etc., as opposed to necessarily, given the small number of dwelling units being only 7, as opposed to a communal.
Yeah, that would definitely be our preference, and we did specifically design the garbage storage spaces on each dwelling's lot, such that it was easily provided out to the street with no need to traverse any stairs or anything like that.
We've built quite a lot of buildings over the years, and one of the things which is a constant annoyance to the owners' corporations is stuff to do with garbage disposal. The more that the individual people are responsible for their garbage, the less aggravation there is, because they keep blaming one another. If there's any communal area, they throw rubbish in the communal area, it gets a mess, and then the owners and residents start arguing with one another. You did this, no, he did it, and whatever else. If the council can pick up from where we're proposing, if the residents are able to put the bins out onto the street, that is the happiest circumstance for the residents. From the residents' point of view, that is far, far much better than getting them to take their bins to the communal area, where inevitably, one way or another, it just turns into a big mess. And I don't want to use any words there that, with big panel, but
we understand where you're coming from. We will have regard to what you've said, and we'll also have regard to council's policy and to the merits of the situation before we come to our determination.
Thank you.
Okay.
Thank you. Thank you very much. Nothing further, so we'll move on to the next. As always, the panel will make its decision this afternoon in closed session after this public meeting, and our decision is generally on the website at least within 48 hours of this meeting. Thank you.
Thank you, Madam Chair.
Thank you.
Very well, we'll now move on to item number 2. And item number 2 is 58 Cowdroy Avenue, Camaray. And this is a development application for the demolition of the existing dwelling and the construction of a new dwelling and associated tree removal and earthworks. For this matter, we have a number of people who wish to address the panel. Number of submitters, so I'll invite those first, and then we will ask the owner and the architect or his representatives to also address the panel. The first person I have on the list or people is Tim and Carolyn Keith. Are you online as yet? I can see you. Online. Yes, you're online. Yeah. Thank you very much. Very well. Yes, I just note for the record that we have all inspected the site. And we understand that you are a neighbour in the area, so if you would like to address the panel.
Thanks, Chair, and thanks, panel. So, yeah, we're Tim and Carolyn Keith. We're the direct western neighbours to the proposed development application. We live at number 56 Avenue. We've made detailed submissions both to the panel and to the council on this application, and in those submissions we talk about numerous reasons why we object to endorse the council's recommendation to refuse the application on numerous grounds. As it impacts us, there's severe view loss, significant overshadowing, a loss of privacy, very negative visual aesthetics, and reduced amenity across our living areas and our garden and bedrooms, as well as a loss of privacy. And what we'd just like to make is we have concerns with the application.
Sorry, just one moment.
And some of the other details.
Sorry, Mr. Keith, can I just ask you to repeat the last sentence? You dropped out.
Okay. I was just
could everybody else make sure they're on this? Yep. Thank you, Mr. Keith. Yep.
I was just saying the last thing is we just want to say we have concern with the veracity of some of the information in the application as it relates to heights and some of the other compliance information, ground levels, etc. And that's also been detailed by the council in some of the concerns as how that fits. So we just wanted to make our objections known to the panel.
Thank you very much, Mr. Keith. And you can stay on and listen to the rest of the matters. Ian Glasson and Maria Satori. Do we have any?
I'm just waiting for him. I did unmute him, but then he muted himself again, I think.
Oh, he probably thought I'm trying to. Ian Glasson, can you just, yes.
I just unmuted. There we go. Okay.
Yep.
Hi, I'm Ian Glasson. I'm a neighbour at 54D Cowdrey Avenue. So we're to the west, 2 doors. I'm a neighbour next door to Tim and Carolyn Keith, who are immediately next door. I'm showing, I know you've seen the site, but I have in the background, and if you can see that, you can see the existing house. And out of picture is the top of the house at the moment. I have basically 2 objections to this development, which I believe is simply over the top. The first is the height, and ever since the Hanging Gardens of Babylon, I think mankind's realised that when you have a steep slope, you terrace down the slope or step down it, that to go vertically out just creates a massive structure, and that's the problem we have here. A really extensive height that makes a huge block to the west and blocks out the skyline, and with all the ensuing problems. The second issue I have is the extent of the development. And you can see in this area, which I know you've seen the site, we have quite a good naturally green environment and well stepped back from the foreshore due to obviously previous prudent planning decisions. The current plan sees further extension of the house to the north, virtually to the waterfront, and basically blocks out what was otherwise a green environment along the front of the harbour. So those are the 2 biggest issues. But clearly it's just simply a massive expansion over the top and unsuitable for the area.
Thank you very much. And I also had listed Maria Satori. Is she wishing to?
Oh, sorry, I'm speaking on behalf of both Maria and I.
Okay, thank you very much. And the next person I have listed is Thomas Blamey.
Thank you, Madam Chair. Yes, I'm 52 Cowdrey Avenue. I'm very concerned about this proposed development on a number of grounds, but it is so totally out of character with every other house along this foreshore that I think it's going to be a real eyesore, and it's also going to completely change the character in that little pocket. Unlike everything else along Long Bay and for that matter, Willoughby Bay, because this project intends to take over pretty well the entire site, leaving very little room for green space, which is a feature of our properties all along the water here. And it's also extremely high. So even though I'm not directly affected by the overshadowing as Mr. Keith is, and presumably Mr. Glasson and their partners. Nevertheless, it will obstruct views along to the east from all of our properties along this foreshore. And I think that's very unfortunate and really unnecessary. I was also concerned about the finishes that are proposed for the building. I mean, if you look at the developments or the sites around here, some of which go back a long way and some of which are very new, they're all sensitive to the environment. This one will be clad in a fairly garish manner and really unsightly, I feel. So I think just not a very good job has been done of working out how to use this site to its best advantage. And it is a beautiful site, like all of us are privileged to have here, but it would be such a shame to see the character of this neighbourhood had this eyesore plonked right on top of it, and so much of the land taken over by the building rather than enjoying the foreshore and having it, compatible. So those are my principal objections, and I did file that with the council too. Thank you, Madam Chair.
Thank you very much, Mr. Blamey. Mark Solomon. Thank you. And if you have any questions at any time, just stay. Mark Solomon, thank you. You're on mute.
Sorry, panel members. How are you? Thank you for the invitation. I'm speaking on behalf of the owners of 2 Folly Point, Camaray, which is the property to the east. Now, we have put in a submission, no doubt that you've all probably read. And I'm not going to reiterate on the issues that have already been raised by the other neighbours, but one of our big concerns is really the lack of information that was provided in the development application to make a really considered assessment of it. Now, we've noted that in our submission. One of the things that concerned us was that the properties on either side weren't clearly defined, so you couldn't get a sense of what the scale, bulk and proportions of the proposed development is. And we've had to do our own assessment on that and overlay our own property onto their drawings. And, we've shown, as agreed by council, that the scale and proportions of the proposed development are not in keeping with the scale and development in the foreshore area. I think this provides a very good opportunity for the applicant to go back and actually have a good study of the topography of the land and the streetscape as viewed from the foreshore area. And you will note that most of those old and new developments are have quite a fine detail, and they are quite recessive in the landscape backdrop. So without going on the other issues to the other neighbours, such as overshadowing and outlook, we support council's decision, their consideration of the approval for its refusal, and we hope that the applicants go back and put a more considered application together with appropriate documents that can clearly demonstrate that any future development won't pose such significant impacts. Thank you, panel.
Thank you, Mr. Solomon. Now, I have two others from 2 Folly Point. Were you speaking on behalf of the three of you, Mr. Solomon?
Oops, muted himself again.
You've muted yourself again. Got Raymond.
I'm happy for them to speak if they wish to, but I'm not sure. I think we'll just leave it at that.
Is there anything in addition that you wish to say, Raymond or Stanley? We don't need to hear the same submission, but if there's anything further that you wish to add.
Good afternoon, Chair and panel. I've got no additional comments.
Sorry,
Raymond.
Raymond.
Yes.
Yes.
My name's Raymond. I'm the architect on behalf of the owners of 2 Folly Point. Will probably not say much further than what Mark Solomon has covered, so I have no further comments on that. Thank you very much.
Fine, thank you. And Stanley Ewan?
Oh, I'm just a listener today, so I will leave it to my consultant, Mark, on behalf of me today.
Okay, thank you very much. Great.
Yeah.
Now, the next person I have is Anthony Solomon, but I don't think, is that related to you, Mark?
No, he's the architect.
He's the architect for the development. Okay, rightio. Now, we just have, on behalf of the applicant, I've got the applicant himself, Paul Etherington, and Anthony Solomon, the architect. And I will say that the panel has read and noted the 3 submissions that were made in support of the application, as well as the other submissions that were submitted. So, Mr. Etherington, can I invite you to address the panel, or would you like to start with your architect?
Oh, I think we'll start with Mr. Solomon.
Okay, fine. Thank you very much. Mr. Solomon.
Well, thank you very much for the opportunity to speak to you, and no relation to Mark Solomon. I do know him, but
yes.
Look, I guess from the outset, and you've all seen the site, we just have to step back a little bit. Like most sites along this area, they're very steep and difficult to deal with. We have this particular site is hamstrung in many ways, and there's a foreshore building line, so you can't go too far forward. There's a board silver underneath which can't be diverted, so you can't. There's a limit to how low you can go, and then the main one, of course, is the maximum building height, which almost always gets pierced in some way on all of these sites because it's impossible to have any building totally compliant with the 8.5 with the height limit on a very steep site like this, and none of the neighbours comply with this, nor does this proposal. But that is the threshold issue: is how much of this proposal goes outside of the maximum building height, and as a consequence, what is the effect on the neighbours? Now, you also have to consider the long-term resident, the people that want to live here, and this is their life. They want a house of reasonable amenity, and they are fully aware of all the constraints that are locking them in. And we submitted a DA that we thought was very reasonable in that it did step down the side. It had a sloping roof, and it is reasonably high at one point because it can't help but be that. But you also have to remember that on these sites, which follow the coastline, they stick further and further out, and therefore the sequence of homes would also follow the natural contours. Unfortunately, number 56 is cradled well back towards the street, and the existing house at 58 is about as far forward as you're allowed to go. So there are many constraints upon this this site and the subsequent outcome. After we put the DA in, there was meaningful consultation with council, and we did make a number of changes. I can't actually see them in the report, but the building was lowered, it was pulled back. As requested by council, the materials were changed to sandstone at the base. There was additional diaphanous screening with planting. So there are a whole raft of changes made, which went to Lisa Kamani and to Robin Pearson. Obviously, in council's report, they don't believe this is enough, but we believe that we've come a long way to ameliorating the concerns the council had. So there are other issues, like in the report it says we don't comply with the site coverage. Well, we do. One of the changes was, besides reducing the footprint, was to remove the garage. It's now nothing more than a car deck. Now, the definitions say this is not site coverage, and but council have chosen to use that as site coverage, which is a little bit confusing for us because we've got to have other jobs at North Sydney with not dissimilar situations where a car deck is not part of site coverage. So in terms of the numerics, we've got it to a position where the only thing we do not comply with is the maximum building height. Now, that's open to negotiation, I'm sure, but I don't want to keep you for too long. You're all learned people, you know the constraints and the difficulties, but it's always very useful, I think, to hear from the actual end user, the person who pays the rates, the person who's going to live there. So I'll put you over to Paul Etherington. Thank you.
Thank you very much, and we will probably have some questions of you as the architect shortly. Thank you, Mr. Etherington.
Thank you, committee. I did drop off some material as well with some diagrams. I hope that made it into your bundle.
Well, I'm sure it would be in our bundle if it was. When did you drop these off?
Yesterday.
Yesterday?
Yes, there were 4 items, 4 various plans. There was.
We only received the written submissions.
We received the written submissions in support, but we didn't receive the 4 plans that you refer to now.
All right, we can deal with it in due course. Look, good town planning requires a detailed analysis of a site by a planner and how the planning law applies to it to produce a satisfactory outcome for society generally. But when you look at first blush at this recommendation before the committee, there are a number of contradictions, and I've got 2. The one is that the rear setback is too forward, but we can't move it back where the trees are because they have to be preserved. So that then leads to a bulky house. But the bulky house leads to an impact on the view. A second one is that the rear setback is too forward, but the house has direct view into the neighbour's windows. So let's push the rear setback forward. So that means the neighbours then miss out on their view. So this has become a bit of a black urban comedy, but one of the things that is consistent in the objections of my neighbours, only one couple of whom I've actually met, is the concept of selfishness. It is ringing through this application. More fundamentally, when you analyse the recommendation by the planner to this committee, there are 5 things which jump out of you as a concern for the council. One is the breaching of the 8.5 metre height limit. Secondly, the material of the construction being metallic in nature. 3 is the preference for a stepped building which hugs the topography. 4 is the alleged site coverage of 60%. The rear setback is the 5th point, and whether or not it is well forward of the western properties. I'd like to respond to these 5 points. The point of the 8.5 metre height limit, you'll see on one of the documents that I referred to, which hasn't apparently caught up with you, is at page 32 of the report of longitude planning submitted for the DA for the neighbouring property at number 56 in September 2019. It acknowledges that a departure from the 8.5 metre height of building standard for that property due to the steeply sloping site, it's described on page 33 that would be unreasonable for it to comply. Further, the report prepared by Mark Solomon's planner, which was Plan Urbia, and that was dated 11 April 2020 on behalf of the owner of 2 Folly Point, refers that it is agreed that the steep topography of the land makes strict compliance with the building height controls unreasonable. So there are 2 reports commissioned by our east and west neighbours, and we wholly agree with the point that they've just made. The current height of the improvements at number 56 were approved to be increased from 13.12 metres to 13.175. In other words, 5.5 centimetres. But more importantly, Council did not hesitate to approve improvements over the 8.5 metre height limit to the extent of 4.675 metres, whereas our property in comparison exceeds the 8.5 height limit by 2.584 metres on the amended submitted plan. But apparently our breach of the height limit by 2 metres less than our neighbours is much more significant and worthy of criticism. Where is the consistency of council? We certainly know where the double standard is. The planner says that the height of building development standard has not been correctly identified. All I can do is refer you to the plans by my architect, which show precisely by way of the yellow dotted line how the house exceeds the height building limit. Dealing with the issue of the material of construction, in Council's letter dated 29 April 2020, the planner stated that the natural materials and colours should be used that blend with water, foreshore, sandstone and vegetation. We have amended our plans to incorporate a considerable inclusion of sandstone, and the essential dark colour proposed by the zinc will be less obtrusive than some buildings, in particular 2 Folly Point in its appalling stark white. No recognition is given to that fact that we have taken Council's advice and added extensive sandstone to our proposal. We also note that number 50 Caldroy Avenue, some 8 houses away, was constructed in 2016, significantly of metallic exterior. The third issue is the stepped building hugging the topography. In her email dated 16 July, the planner refers to a more skillful design being called for with reduced internal volume, stepping down the slopes, utilising the existing levels. Well, with all due respect to the planner, these are matters for the owner and the owner's architect, and we'll take responsibility for those. The landscape calculation, well, Mr. Solomon has dealt with that. I'd now like to turn to the rear setback. I say the following. 1, the proposal complies with the foreshore building line. 2, the proposal now stands 400 millimetres back from where the original house was proposed and lodged with council. 3, and most importantly, there is a word that I have not been too familiar with, but which I'm becoming very familiar with, and that is the word trapezoid. The fact that the property is of trapezoidal shape is not mentioned by the planner. I produce a sketch to you, which was a plan prepared by Mr. Graham Surveyor, which shows that the most northerly point of this property and the most northerly point of our neighbouring property at number 56 is different by the measurement of 9.97 metres. Further, the most southerly point of our neighbouring property number 56 and our property is 8.34 metres. This shows that number 58 is a property that is positioned more north than its neighbour at number 56. Consequently, the existing homes on those properties are such that the house at number 56 ends in a line behind where number 58's house begins. The placement of the home at number 56 on its southern edge means any reasonable building construction being undertaken on number 58 will risk impacting on number 56's view of Long Bay. The homes on these two properties are not next to each other. Number 56's house is on the southern edge and number 58's house is in the middle of its block. In Council's letter dated 29 April 2020, the planner says, the proposed building extends significantly further towards the foreshore to the north of the site than the neighbours to either side, especially the properties to the west of the site. This is surely a eureka moment for the planner, but nowhere has the planner recognised that the site is trapezoidal in shape. In other words, our property juts into Long Bay further north than any other property to our west. This fact is not even superficially mentioned by the planner in her recommendations. As you are all no doubt aware, clause 4.6 of the North Sydney LEP, if I may paraphrase, says, the objectives of this clause are to provide an appropriate degree of flexibility in applying certain development standards and to achieve better outcomes for and from development by allowing flexibility in particular circumstances. Development consent may be granted even though the development would contravene a development standard imposed by the environmental planning instrument. This means the planning laws need to be flexible to ensure better outcomes even when a development standard has been contravened. For example, the 8.5 metre height limit. The flexibility required is not being applied to this application. I'd now like to talk to you about the view. Committee, this is really what this is all about, and it all emanates essentially from number 56, who has been referred to on page 5 of the recommendation as, quote, the immediate west, inverted commas, where the planner says this proposal will result in unreasonable view loss for several properties around the site, and particularly the neighbour to the immediate west. To begin with, we now have two planners who say that the strict compliance with the height limit is unreasonable due to the topography of the site. These planners have been retained by two objectors, not by the applicant. We also now see that number 58 is shaped as a trapezoid, which pushes our property more north than any other property to its west. The topography is such that number 58 has an existing house in the middle of its land in comparison to number 56, which has its improvements at its very southern edge. We therefore now have a situation where number 56, which is built at its rear, now wants to regulate its side or oblique view from where it is currently located, and thus economically sterilise to a certain extent the ability for number 58 to be utilised from its current undeveloped status. The 1960s house that is built on number 58 is crying out for redevelopment. It is proposed to spend some $5 million in this pandemic on the redevelopment of that property. That fact is unfortunately something that the planner cannot take into consideration, I accept, but I think it has some relevance for the committee to consider. Turning to the development consent that was granted in September 2019 under DA 15319, some interesting points jump out at you, which have not been considered by the planner. I produced a plan for you to look at, which is a view which sets out the detail which the owners of number 56 referred to in their DA and how it traversed number 58. The view is described in that document as Long Bay views, and it hardly touches number 58. But when number 58 puts in their application, the oblique view traversing number 58 is described by the planner as unreasonable view loss to number 56. I find that most curious when their own document at number 56 now condemns them. More interestingly, when you look at the plans of number 56, you see the following. 1, the balcony on the top floor is unimpeded by the proposal at number 58. 2, the eastern wall of number 56 has 5 windows affected by number 58's proposal, and I've given you plans of those. 1 is a powder room, 1 is a pantry, 1 is a staircase, 1 a small kitchen window, and 1 is in a corner. The corner seems to be where sliding doors end, which may well impact the view in themselves. Further on that level, there is a structure which impacts the view for half that floor, the living floor. It may be structural in nature, it may be a fireplace or a bookcase, I can't work out. Finally, what is impacted in the seated dining area? This is of significance because the second step in the case of tenacity is this: from what part of the property the views are obtained. For example, and I'm quoting, views across side boundaries are more difficult than the protection of views from the front and rear boundaries. In addition, views from a standing or sitting view may also be relevant. The Commissioner said sitting views are more difficult to protect than standing views. He goes on to say that the expectation to retain side views and sitting views is often unrealistic. So I'll repeat what Senior Commissioner Rosa said. The expectation to retain side views and sitting views is often unrealistic. Well, number 56 is now trying to retain its view from its dining room as shown on its plans. Thus, it hits both the concept of sitting and side. It effectively achieves a quinella of unrealistic expectation. In her email of 16 July, the planner said our view loss diagrams, which I've supplied to you as well, which you haven't got unfortunately, had only dealt with the quantification of the view loss and not the impact for the whole of number 56. Well, I think my analysis of the stairwell, the powder room, the kitchen, the dining room, and there was another. I think my simple analysis has shown you how inadequate this planner's view loss analysis is, but perhaps she spends a lot of time in stairwells, powder rooms, and pantries. The alleged view loss factors need to be considered with the fact that number 56 is extending with council approval its third level balcony by 4.7 metres further north. Thus, the view that needs to be considered as impacted will be very different once constructed to the one represented today in the photos supplied by number 56 with its objections. This fact that the current view is not to be the future and imminent view was not mentioned in the recommendation. Why? The failure to advise the committee of this material fact is damning.
Can I just say that we are fully aware of the approvals for that adjoining property? Yes.
And I'm making the point that there is no mention of the fact that the balcony is being extended further north by 4.7 metres is mentioned at all in her recommendation. Had the planner considered the development consent from September 2019, only 4 months before we lodged our DA, she would have seen that the impact on number 56's view is minimal. So my concluding points, committee, and thank you for bearing with me, are as follows. There is an argument that the 8.5 metre height limit along Cowdroy Avenue has in fact been abandoned by council. I hope we are not forced to prove that fact by survey and digging through many council files. The height limit of 8.5 needs to be exceeded in this proposal because of the topography of the land. However, as mentioned, the non-compliance is only 2.584 metres, which, compared to our east and west neighbours and the rest of the street, is below the average. And is it not fair to ask that number 58 be treated like other properties? Or does number 58 have to be singled out because it is one of the last properties to be redeveloped in the street? 2, you are assessing our revised plans. We have reduced the height by ½ a metre. We've brought the building back 400 mil from the foreshore of the initial proposal. We have added sandstone to soften the appearance. 3, We pointed out in written correspondence with Council on the 12th of July that the constraints with this proposal were the topography, the foreshore building line, and the sewer main. The planner has not given any recognition to the fact that the sewer main, which dissects the middle of the block, prevents deep penetration into the rock base, and this impacts on the structures that can be built on this property. However, curiously, the planner objects to, inverted commas, extensive excavation, inverted commas. I think this means we agree with the planner, as we don't want extensive excavation, but it follows that this may cause an impact on bulk and scale and thus view loss. Effectively, you can't win. At the beginning of my submission, I spoke about how good town planning requires a detailed analysis of the site to produce a good outcome for society. In my respectful submission, this analysis by this planner is thoroughly disappointing due to the superficial nature and subjective approach she has undertaken. My understanding is that this committee finds it very difficult not to follow a recommendation of a council planner. That causes me much disappointment as an applicant because the litigation genie will be let out of the bottle, which will waste so much of ratepayers' money, something the mayor has told me is she's very much against. I recommend we delay consideration of this proposal for 1 month until the 2nd of September to see if a compromise can be had, perhaps with the head of planning's involvement, as I want to reach a fair outcome. The delay will also give the committee further time to examine the deficiencies of this recommendation, as there is material that simply has not been put before the committee. And in any event, that is my suggestion to the committee, and I thank you for your time.
Thank you. When you're saying information hasn't been put to the committee, are you referring to the information that you lodged yesterday?
The
thing is, with respect to the approval of the adjoining house, we have that file here with us, so we are fully aware of what has been approved there. So we do have the facts in terms of that, but we don't have what you submitted yesterday. But as you would be aware, it would be hard to have regard to it, given it's at the 11th hour, so to speak. But I hear, what was the information that you had submitted to the council yesterday, Mr. Etherington?
We gave you a view loss analysis from Mr. Graham's surveyor.
All right.
Showed the planner referred to it as a quantitative analysis of the view loss, which is what usually surveyors do.
I've seen something from Mr. Graham, so just one moment. Didn't we receive something?
It was in a letter form.
It was in a letter?
With some diagrams.
Yep. Yes. So we received something from Mr. Graham. I read it just before, actually.
It was provided to me some time ago, and I showed it to the panel earlier today.
Yes, I had seen it and I read it. Yes, so it has been provided, Mr. Etherington. The information that you provided today was submitted earlier. So we have been privy to that. Thank you.
Good.
Yep. Thank you for clarifying that one. Now, I think the panel may have some questions, either of you, Mr. Etherington, or in particular the architect, Mr. Solomon. Mr. McInerney?
No, thanks, Madam Chair.
No? No?
No.
Mr. Brigdon? No? Okay. We do notice that the height exceedance is, yes, there has been variations along the area, but at the same time, Mr. Solomon might be more readily able to answer this question. It just seems that the height lines that have been drawn on the plans, they don't look like they've been related to the existing ground levels, Mr. Solomon, which is the requirement.
With regard to the heights, we've
Yes.
had Surveyor Peter Graham do 8.5 metre height lines on the middle of the site, the eastern side and the western side. They've all been plotted onto the drawings. So these are certified heights for the site. Similarly to the height poles which were erected, they were certified by the surveyor.
Yes, we saw the height poles and we saw the certificates in there, but the 8.5 line on the plans doesn't appear to correspond with the existing ground level.
Well, it does, because it's the dotted lines, which, for want of a better word, cascade down the side.
Yes.
Correspond with, they're the lines from the surveyor.
Well, anyway, that's one thing that we'll look at.
But also, the height poles that you looked at, remember the amended scheme is half a metre lower than that. That was put up for the original scheme. So you can just, and we've also, I don't know if you went up there, we erected a scaffold to represent the height of the neighbouring balcony, and that was also certified by the surveyor. And that's the only way we could possibly come up with something that could give us an idea of view loss analysis from number 56, because, well, access hasn't been forthcoming, so there's no other way to do it other to actually gauge what the view loss might be from the balcony of number 56. That scaffold, you probably saw it still sits there, but so anything relating to height has been certified by the surveyor.
Okay. And then just the other question is, there was mention of the sewer, which is, we can see that on sheet DA08.
That's right, yes. So
and
the sewer...
but I suppose the issue is, I can see where the sewer is, and does it project further forward into the foreshore area?
Well, it runs on a diagonal. If you go to the side, there's a diagonal.
Yeah.
The survey, it shows
on the survey.
diagonal. So obviously, when you look at it
yes,
in a flat plane elevation, you see part of it, the back part of it's further forward than the front part.
Right. Okay. So I suppose the issue is then there's the opportunity forward of the sewer to step it down into to correspond more with the topography of the land.
Well, the sewer's not in a great spot, but you can look at anything. But we've made inquiries to Sydney Water about the sewer, and unfortunately, because previous occasions we've actually diverted the sewer, but this one is quite large. And
it's a major sewer line, I can see that, yes.
It's not diverted.
It's a main. Yeah. It's a main, it's not private pipes.
Yeah.
So,
and the issue about site coverage, it just seems that there would appear to be little space or opportunity to plant canopy trees on the plan, and the site coverage you're saying now complies, but if you take the roof off the garage, but how are we getting additional landscaped area by doing that? Mr. Solomon?
Area was already...
Could you come forward a little bit so that we can hear you a bit more clearly?
Yes.
Thank you. Yes, thank you.
The landscaping area was, we made the footprint smaller, and we changed the area around the pool and down towards the foreshore so it's not touched. So there's far less hard paving. The footprint is smaller, and we've taken the roof off what was the garage. So we've made this building comply with the site coverage. The resultant landscaping is, well, we say complies, but even if it's very close to complying. But I think what Paul alluded to earlier was that he is prepared to look at amendments and in a meaningful way with Council's senior planner. So that was his suggestion earlier. We're prepared to do that because all parties want to have a reasonable outcome. So
clearly, and this panel together with Council are always keen for us to move forward and to get an acceptable outcome, and that's the role. With respect to the deferral, there's also pressure on that development applications be determined within a certain time frame, as you're aware, and I would just say that further amendments can always be, as you would know, Mr. Solomon, because you've been before us before, further amendments can be done, and they don't have to be substantially the same, but further amendments can be done via an 8.2 request to vary the development application, and that's always something that is facultative to allow amendments to be done.
But I think just to expedite the matter, I'm speaking on behalf of the owner here, it would probably be a quicker outcome to delay it by 1 month and have very meaningful discussion and amendments that hopefully all parties can be happy with. Because if it goes down the 8.2 or something else, then it can get lost in a quagmire of bureaucracy.
Well, the 8.2 is designed so that they're dealt with relatively quickly as well. There is a time frame around them, so it doesn't delay matters. An 8.2 is an efficient and cost-effective way of dealing with issues that haven't been resolved before they get to the final or get to determination.
6 months?
They have to be completed within 6 months, and generally you would find that there would be open doors to further discuss plans immediately. So council are not interested in delaying it. In fact, as a panel, we can direct that any 8.2 be done in a timely manner. That is part of our role as well. I mean, the other thing, I suppose, the panel hasn't got the benefit, and I don't expect you to come up with an amended plan from the bottom drawer at this point in time either, but the panel has not heard what the applicant is prepared to do, and perhaps that might be better left to another day. But I'm just trying to understand. There is a fair bit of difference between what we see in the plans and what we hear, but what is it that the applicant is prepared to do to, I will say, for want of a better word, shrink the development?
Well, that's I can't speak for the applicant exactly, but
well, you've just asked for a deferral to allow for
the architect, I know pretty well.
So I'm just trying to understand what can be achieved in that, and it can be achieved through an 8.2 as well. But just let me know what you're sort of thinking. Otherwise, I mean, that's fine. But I'm just trying to understand.
Well, the critical issue is the height. The height where it penetrates the building height plane, and the subsequent impact on number 56. That is the critical issue. It has been from the start. If that can be somehow reduced, that impact, then a lot of the side issues would probably drop away. So the challenge for us is to either pull back or lower the point or the part that most impacts the neighbour without severely compromising the livability for the owners.
Yeah.
I mean,
I'm just on that, in that regard, Mr. Solomon, I'm still looking at that section DA08, and there does appear to be capacity for the front portion of the dwelling to be brought down to what is existing ground level or nearer to it. Do you want to have a provide further comment? So, Mr. Solomon is with me?
Yeah, I'm with you.
Yep. Is that what you're talking about?
What I'm talking about is, yeah, I pretty well know what to do, but I need to discuss it with both Renata and Paul first.
Yep,
because,
I understand that. Yeah, I don't want to put you in a position, but I have to weigh up, or we have to weigh up as a panel, whether in fact we defer it or whether in fact the appropriate path is to go down the 8.2.
Yeah,
so that's the only reason I asked you the question. It was just in fairness to you.
Okay, but given the owner has submitted material yesterday, which is not in front of you,
Yeah, we do have the material. Yes, we do. It was submitted earlier.
the trapezoidal.
Yeah, we do have that material. Yes. Yeah.
Given that there hasn't been much time to digest it.
So can you actually say what documents you submitted yesterday so we're quite clear as to what they are?
Can you show us the document you submitted yesterday, and we can then make sure that we do see it. But I did see something this morning that had the surveyor's
Yes, we saw that.
and a planner's note on it as well. But just show me what you wanted us to look at, Mr. Etherington.
It's the plan by Mr. Graham showing the 9.97 metre length of the two northern points of 56 and 58, and also the 8.84 metre. Yeah.
That's a survey.
No, it's.
So what does it look like? Just if you can show it to me, that would be great.
That's half of that's what it looks like. Can you see that?
Yes, well that's what I think we saw before. Yep.
Okay. And it's got in red writing at the front the 9.97 metres, and on the southern edge the 8.84 metres.
Okay, just turn it around again. Sorry, now that you're in the full view for us. Okay, and that's by Mr. Graham. Okay, and what's the date of the plan?
24th of August. Wait a minute. Yeah, 24th of August 2018. So it's not. He's just used it as a plan to show the measurements. He actually hasn't. It's not a perfectly drawn survey in comparison to his other.
What's the date of his report?
It was not a report, it was a sketch drawing which he drew. I mean, I've got his email where he sent it to me if you want to see that.
So what was the date of it? I just want to know whether it's something that's in our papers or not.
We've seen the sketch drawing. We need to know with certainty that it's the same document. So.
Okay, if you can just bear with me. I know where it is in my computer. It's not that one. It's got that, and then it's got that as well.
I'll just send you a message.
Can you just bear with me 1 minute? Ah, yes. Am I going to cut them off? So let me just do, what's this? That's all.
This is it here, isn't it?
We're just locating it now on the email.
Review, can you just ascertain that?
This is from now.
Okay.
So yeah, that's the same one that you just looked at.
This is for
I've found it on my emails.
I
think this is it.
I think this is it.
We've got one on the 12th of July.
12th of July.
Yes, that's it.
Right, okay. Rightio. I just wanted to confirm, as Mr. Brigdon said, it's just as well we've got the same document. Okay. Mm-hmm.
And are they the only two documents that you dropped in yesterday?
Well, no, I dropped in parts of the development application submission by the neighbour at number 56, which showed their interpretation of their long bay views. It also showed the third floor, which is their living area, which is going to be impacted by the built house next door, which is going to, it showed the 5 windows, powder room, stairwell, pantry, kitchen, dining. And I thought you should see what was being adversely impacted by this view. And the effect is not much is being impacted at all. It also shows the balcony being put forward 4.7 metres further north to what exists today.
Yep.
Okay. So sorry, can I just interrupt? I'm sorry, Carolyn from 56. Those side windows are all obscure glass and they're just to let light in. So none of them are actually for a view access. Our third floor is not living. It's actually bedroom and bathroom. Our living is on the middle floor and the ground floor.
Okay.
And we also thought for a knockdown that the 8.5 metres complies and is very different to when you're staying in an existing structure.
Yeah. Anyway.
Yeah.
Just wanted to clear up more lies.
No, look, please. I do not. This panel is not here to hear matters like that. In fact, it's very inappropriate. So we've just wanted to clarify that we had all the information before us in which to make a decision, and we do note that the officer's report does refer to material which I don't think was found to perhaps to be terribly explanatory. But anyway, we will have a look at all the material before us before we make a decision.
If I can just say something, I just don't feel that there's been enough context analysis being done.
Now, Mr. Mark Solomon, you're
Yes.
from number 2.
2, yes. I don't believe there's been enough.
Can I just say that this is not a debate. This is allowing people to be heard and to ensure that we have all the information required in which to make a decision. We are aware of the approval at number 2, Folly, as well as number 56. So I just wanted to say that, and it's not here for a debate. Thank you very much.
I'm not trying to debate. I'm just trying to convey that there's just not been enough contextual analysis undertaken.
I think you've made that point, so we're aware of that. Thank you.
Yeah. So, okay then. No further questions from the panel. No. Thank you all very much, and we do understand that these decisions are very important, and you can all be assured that we'll be taking into consideration very seriously all the written and oral submissions that we have received and the information before us. As I said to the others, our determination will be on the internet within 48 hours. Thank you very much for attending this afternoon. Right, we will now move on to the next item on the agenda, which is number 3. And this is in respect of the matter at 85 Bay Road, Waverton. This is alterations and additions to shop top housing, and in particular an attic for units 1 and 2. I don't have anybody here from the public who wishes to address the panel. I do have the town planner for the applicant, Mr. Greg Foster. Are you here?
I am.
You are, thank you. And thank you for your patience. And if you would like to address the panel, I myself don't have any questions. Does anyone on the panel have a question? No, we don't have any questions, but if you'd like to make a submission to us, we're here to hear it.
No, I'm just here to answer any questions of the panel.
Right. Okay. I think that this is one that has been discussed with the planner responsible, and you're happy with the report and the conditions.
We are.
Thank you. Thank you very much, Mr. Foster. We will make this determination, and you'll see our decision on the internet in 2 days.
Thank you.
Thank you. Bye-bye.
Bye.
Okay, that takes us to item number 4, which is 35 Myrtle Street, North Sydney. And this is a modification application for a DA that has previously been approved for residential flat above shop top housing, so to speak. And the number of submissions that were received on this matter exceeds 10, so it qualifies for coming to the panel. We have 3 people who wish to address the panel. We have Martin and Mary Ryan. Are they online?
Yes, I'm present.
Oh, sorry, thank you, Mr. Ryan. And you're speaking on behalf of Mary Ryan as well?
I am, that's correct.
Thank you very much. Would you like to address the panel?
Yes, certainly. Can I ask who else is speaking, just for my awareness?
Oh, yes. And you'll be able to be online to hear all of the other speakers as well. We have Nick Rickard and we have James Lovell. They're for the applicant, both of them.
Oh, okay. So thanks for that clarification.
Okay, thank you.
So firstly, I take it from me that I speak on behalf of all of the 13 original objectors to this matter who live in Eden Street, West Street and Myrtle Street. We keep in close contact. We have some concerns with the process that's been followed here because we became aware that this matter was before the panel today only last Friday. And despite our best attempts to navigate the process, we obtained the council officer's report only yesterday, by which time written submissions to this forum had closed. So under those circumstances, I ask you
This is your opportunity.
to place appropriate weighting on what I say, given that it represents many people's views who otherwise couldn't express them under the process we're following. The first point to make is that the council officer proposes accepting the current proposal on the basis that it's substantially the same as what was originally approved. The residents and I would like to dispute the notion that it's substantially the same on two grounds. Firstly, the roller shutter. The roller shutter was never part of what was originally approved. And the key point here is that it is very large. Judging by the diagrams, it's 4 metres by 4 metres or thereabouts. Now, one would intuitively assume that a roller shutter of that dimension would be very noisy and would rattle. So the onus should be on the applicant to establish that it won't. However, the acoustics report, which became available to residents on the council website only last week, the acoustics report does not reference the roller shutter specifically at all. So we can't be clear what implicit assumptions are being made when the acoustic report simply weighs through the entire development holistically as being compliant. The key point here as well is that the only condition that's being proposed on this roller shutter is, quote, to ensure it does not rattle, unquote. I'd put it to the panel that that sort of a condition is effectively unenforceable. It's too vague. And the applicant having the onus to prove that this roller shutter is not noisy has so far failed to do so. My final point on this one is that the roller shutter is entirely unnecessary. The applicant didn't want it in 2017 or 2018 or 2019 in all the myriad changes that have been proposed that would do your head in on this DA. It's only just surfaced literally in the last few months. So clearly on the applicant's own prior actions, it's not necessary. So what we're dealing with here is an unnecessary cause of noise. So for that reason, we believe what's proposed is not substantially the same as what was approved in the prior DA. The second of the 2 points is to do with the car parking spaces. As panel members will be aware, the floor space of the commercial premises in this DA is quite significant. It could quite easily have 5 to 6 regular staff working there. And depending on the nature of the business, it could quite easily have 5 to 6 or more visitors attending during the course of the day. Now, in the approved DA, this entire commercial area for its staff and its visitors had only 1 car parking space, which arguably was pitifully few. Now, the 1 was approved, but now it's down to 0. The residents submit that 0 is just entirely an unacceptable number of car parking spaces. The car parking space that was originally approved should still be required. And again, on this basis, what's being proposed is not substantially the same as what was approved in the original DA. So that completes my submission. I would urge the panel to approve what's before them, subject only to the removal of the roller shutter, which is not necessary, and the reinstatement of the car parking space, which is necessary. Thank you.
Thank you very much, Mr. Ryan. And you can stay on the line to hear from the applicant's representatives. So could I invite James Lovell and Nick Rickard. Mr. Lovell's online. Thank you.
Yes, thank you, Madam Chair. And panel members for the opportunity to address you. I just really wanted to say that the applicant has liaised with the council's town planner during the process of the council's assessing the application, and that's resulted in a series of adjustments to particular issues that were raised as concerns by the council staff. The culmination of that is the assessment report, which is very thorough. The applicant has been through that in some detail and also considered the conditions that the report is recommending, and I can indicate that the applicant is pleased with the report and is quite comfortable with all of the conditions that it's recommending. So beyond that, I would just refer the panel to the assessment in relation to substantially the same development. I'm sure the panel members are familiar with the criteria that is established for that type of issue, and I think it's properly assessed in the report itself. In relation to the roller shutter door, that's an issue that improves the security of the building, and it has been the subject of assessment by the acoustic consultant. And again, the applicant accepts the recommendations that are included in the report in relation to that issue. Beyond that, I'm available to answer any questions if any panel members have any. Thank you.
Well, just in respect of the roller shutter door, you heard what the submitters had to say. You're saying it's required for security. Why can't you have a panel lift door?
We'd probably, Mr. Rickard, the applicant's representative, is with me in the office. He indicates that that's a possibility.
All I'm saying is that the condition is written in such a way it would be difficult to enforce, and in that regard, that responds partly to Mr. Ryan's concern, but also we all know that panel lift doors are far quieter.
Madam Chair, that's acceptable to the applicant.
And then you heard the submitter's concerns, which were, and I think the submitter is aware, Mr. Ryan, that the modification application has been amended from when it was first submitted, and that's what Mr. Lovell referred to there. But perhaps you could now respond to Mr. Lovell what was said about the allocation of the parking.
Well, I can only say that in the approved scheme there were 6 spaces, of which 1 was allocated to the business tenancy, and in the amendment application 1 space has been lost, and the reason for that was to improve the access from the car parking spaces to the building itself, and in the approved scheme that was less than ideal. So in reconfiguring and improving that access arrangement, there has been a reduction in 1 car parking space. But I'm sure the panel is aware.
I think the issue was raised was the one for the commercial space should be retained. So if in fact you lose 1, it would be for the residential. Is that how you understood it?
Yes, that's it.
Yeah.
Well, that's not the applicant's preference. As the panel would know, the council operates a constraint or a maximum parking provision, so there's no issue to do with the number of spaces that have been provided, because it's below the maximum number of spaces that can be provided under the council's DCP. And it's the applicant's strong preference that the car parking spaces be allocated to the residential units and not to the business premises, both of which satisfy the requirements of the DCP because, as I said, they're expressed as maximum parking requirements.
So would there be any physical impediment to one of them being tied to one of the commercial units?
Look, as I said, the applicant's preference is that not be done, and I understand that at least some of these units have been sold on the basis of the car parking arrangements that's depicted in that plan. It's not to say it's impossible, but as I said, it's not the applicant's preference that a space be allocated to the business tenancy.
Okay. All right then. Any other questions from the panel members? No. Thank you all very much for attending. And as with the other items on the agenda, our decision will be on the internet within 48 hours. Thank you.
Thank you.
We'll now move to the next item on the agenda, which is number 34 McLaren Street, North Sydney. This is internal and alterations to a heritage building, and that is why it is before the panel today. We do not have any registered speakers from the public. And the applicant has not registered to speak. The panel will consider the report and make its decision in closed session later this afternoon. Thank you. The next item on the agenda is item number 6, which is Unit 1495A, Ridge Street, North Sydney, the installation of an air conditioning unit within the complex. And the panel has inspected the site. I don't have anyone here registered to speak, so the panel will once again make its determination in its private session this afternoon, and the decision will be on the internet. I would like to thank everybody for attending and thank the council staff for assisting us and facilitating our meeting today in these COVID times. And the panel is formally, the public meeting is formally closed at 3:30, and we will go into private session. Thank you all for attending.